Hello, everyone, and welcome to our weekly webinars produced by businessperformanceusa.org. Business Performance is a online business interchange where people can come together and talk from around the country. Excuse me. Today we are doing our weekly webinar, and today we have the basic truths about background screening, and this is part 11. It's one of a series of seminars that have been given across these last 11 months by Track One Technology. Track One is a premier background screening organization, and they will be talking today on the quality decisions through individualized assessments. And this is a question, will the EEOC FTC approve? Very interesting question, as a matter of fact. And I find that you'll learn a lot about this particular topic today from Matt Graham. And let me introduce myself. I'm Cynthia Stewart. I'm managing partner with Evermore Services, and I'll be the host today. And I'm going to introduce also Matt Graham, who is very well versed in the whole topic of background screening. Matt is a lawyer. He is also the Executive Vice President of Operations for Track One Technology, as I said earlier. And Track One is one of the few background screening firms that's actually accredited by the National Association for Professional Background Screening. And Matt is one of the few persons accredited in the data arena for background screening. So he brings a great deal of wealth of information and background and history and experience with regard to this topic. And I want to make this time worth it for you today. So be sure to enter any of the questions that you might have into your question feature on your dashboard. And if you have a specific question that's workplace related, be sure to email me at cynthia@businessperformanceusa.org, and I'll be happy to answer those questions or find an expert among our volunteer executives that can answer a question for you. And also be sure that you go back and watch our on-demand webinars. You can sign in to businessperformanceusa.org, and you can check us out on YouTube as well and watch any of our webinars, which we produce weekly, Tuesday noon Central. And we welcome you back every week because we bring topics of interest and topics of pertinence to the business workplace today. So on Matt Graham, Matt has been with Track One for several years now and has worked with them very closely in getting their accreditation and also getting his own accreditation. And he oversees the operations, including information technology, human resources, operations in terms of sales and marketing. So he is quite the man when it comes to background screening for Track One Technology. And we just look forward to what he has to offer us today regarding this topic. And with that, Matt, I'd like to go ahead and pass you the screen over.
Well, thank you for the introduction. Always a pleasure to speak with this group. And today we're taking a little bit different approach in our previous webinars. We've tried to cover a lot of related topics. This time we're kind of going to do a deep dive into one particular subject, which really keeps popping up. It's getting more popular, unfortunately, on the litigation track. More plaintiffs' attorneys are finding ways to turn the FCRA, or the Fair Credit Reporting Act, into a moneymaker for them. In fact, there were a couple of class action lawsuits that were just filed yesterday out of Florida, which will probably end up serving as the basis for yet another webinar on the topic of background checks. But this one in particular has to deal with the issue of individualized assessment. It's kind of one of those nebulous concepts that really, when you look at it, it makes your eyes cross and your head spin, but really unnecessarily so, because I think with just a few slides here, we can kind of show you that you may have already been doing a lot of what's involved in this and just didn't realize it was part of the process. But there are, as with most situations, a couple of gotchas that we'll try to draw your attention to, and so you'll be able to avoid those going forward. So part of the confusion, I think, that comes out of this concept of individualized assessment is that it appears on its face that the EEOC has done an about face and is changing its tune. Most HR managers have kind of come to the conclusion, or just through their years of training, that you have to treat everybody the same. You can't play favorites, you can't discriminate. So there's this mantra, this common drumbeat that goes out there in the HR world of do everybody the same and you won't have any problems. Well, the EEOC has altered that a little bit, and that kind of makes people scratch their heads and say, well, what do you mean? So the concept of treating everyone the same is still pretty much intact, in that you don't want to discriminate based on protected classes. However, when it deals with background checks and the usage of criminal records in the hiring context, there's a little bit of a change. There's a little nuance to this. So even though we've been taught the same process, same screening, same standards when you're looking at decisions, there's just a little nuance here. And really, it's not that complicated. The main thing that the EEOC is trying to do in an effort to prevent workplace discrimination is you can't have these bright line rules of if you've ever been convicted of a crime, you can work here. The challenge with that is that it's overbroad, and based on the historical criminal statistics in our country, if you look at the overall population of offenders compared with the overall population of the United States, there's a disproportionate number of people in the offender class that fall within the protected classes. So that's a lot of lawyer speak and gobbledygook, but I think I can bring that into focus. It's been a couple years now, but in April of 2012, there was a change to the enforcement guidance that deal with the usage of criminal records in the hiring context. And a lot of people, when they heard this come out, they thought, oh my gosh, here's a executive agency making new law. It's a little more nuanced than that. From a strict legal perspective, there is no new law with this enforcement guidance. This enforcement guidance is really just the handbook or the playbook that the EEOC enforcement agents use when they're out there in the field looking for their next victim. I meant plaintiff or defendant, actually. So the enforcement guidance is really just an interpretive. And so the EEOC's response was, we're not making new law, we're simply interpreting Title VII, which has been out there for quite some time and nothing new. But they did kind of drop a little bit of a bombshell, at least it sounded like that for us in the background screening industry. The concept is that if you're using background checks, the premise is you're discriminatory because background checks and criminal records have a disparate impact on protected classes. So that was kind of a bombshell for us. The fact that they start with the concept of you're being discriminatory if you're using background checks seemed like it was time for me to start packing and looking for another line of work. But it's not usually as bleak as it might first seem, and the last couple of years have borne that out. And really, it's not as confusing. It's not as drastic of a change as we first thought, because several cases have come out, additional conversations have been had that bring a little bit of clarity to this concept. And what we've learned is that this individualized assessment concept isn't really all that new, because it brings into play several factors that have always been, or at least for the last 20 years, have been part of the consideration process when you're using criminal records or background checks in general. So the things that you always have to keep in mind when you're using background checks in the hiring context is the nature and the seriousness of the offense. You know, armed robbery convictions are a little bit more warrant a little bit more attention than, say, writing a bad check. So the nature and the gravity of the offense is one consideration. And in combination with that, you look at the amount of time that's passed since the original conviction or since release from prison. And then you're also looking at the nature of the position that person is applying for, or in the case of current employees, whatever position they currently hold. So these are known as the green factors. It came from a case, Green versus Mississippi Railroad, I believe. I think I have that correct. But these are the long-standing factors that need to be considered. And so this revised guidance took those and then said, we also have this concept of individualized assessment. And so some of the things that play into an individualized assessment, which really, if you pick that apart just based on the words involved, individualized, meaning you're looking at the person that's standing in front of you in the application process, and that's where people started thinking, well, you know, the EEOC has been teaching us all about treating everybody the same, so now you're saying I actually have to look at the individual and make some sort of individualized decision. Well, that is in fact what we're looking at. So if you want to just get that out of the way and say yes, the EEOC is changing their tune, fair enough. But I think what you'll see is it's fairly consistent with their overall mission. So some of the things that are involved in the individualized assessment concept is whether or not that individual, either post-incarceration or post-conviction, has had any similar troubles, or whether they've been able to hold down a steady job since that event. Also, just looking at their employment history, either before and or after the offense or conduct. And then whether or not they've been through any type of rehabilitation process, any programs, received any additional education or training. So really what we're trying to do here is determine whether or not this person is truly disqualified from holding a position. The idea behind these bright line rules is when you say that no matter what the conviction, no matter how long ago it was, no matter what was involved, this person's no longer qualified to work in your employ, that's pretty serious. That appears to be a complete bar to employment. And that's basically what the EEOC is seeing. They're realizing that a significant number of individuals, a good portion of the population of these offenders, are pretty much barred from finding employment. And you know, you can get pretty deep into some of the social aspects of things and start looking at rates of recidivism and why those are the way they are. And certainly the lack of being able to find employment would play into that. So in their overall effort to reduce job discrimination, that's what the EEOC is deciding, is that we need to take another look, a harder look at this, and still comparing the original green factors and taking a more individualized approach. Is this person truly disqualified from holding any job? And so as you'll see as we go through this, that question is playing into what the concept of individualized assessment is doing. So looking at employment or character references or any other information that might show fitness for a particular position. Sometimes people they go through federal programs, or they're bonded individuals, and that can play into the consideration. The other things that I think what initially had a lot of us scratching our heads was you have to inquire as to the facts or circumstances surrounding the offense. And, you know, sort of jokingly, I think we were all asking, well, do you have to ask why they stole the loaf of bread? Because they had to feed their family. And I think, you know, there is some logic to it, but, you know, the motivations is maybe not quite as important. But at least, you know, that it may need to be part of the consideration based on what we're seeing. The number of offenses, you know, there's a difference between somebody who had one youthful offense and a hardened criminal with a habitual offender. So the number of offenses needs to play into it. And then there are some other things too that again point to some of these social reports and studies that have gone out. If they were older at the age of, or if they were older at the time of conviction or released from prison, studies have shown that plays into the rates of recidivism. There are some other studies that show once a person has gone 7 years post-crime and not having committed another crime, they are no more likely than anybody in the general population to commit another crime. So it's interesting that that 7 years comes up because a number of our states have adopted statutes that say you can't report criminal history beyond 7 years. And it comes out of this Bloomstein and Nakamura study that talks about the rates of recidivism. So, you know, there's a lot of social policy at play here and a lot of different things that are coming into this individualized assessment. But again, it's all pointing back to this concept of looking at the individual in front of you. Is there any way that you can find a position within your organization? And so what the EEOC really eliminate those bright line rule tests that say any criminal conviction is an absolute bar to employment. So they're wanting us to also develop narrowly tailored screening policies. And we work with our clients to help determine what that means and how to establish that. But I think if you just apply some common sense, you'll see that it's not such a difficult concept. And as I mentioned as I began, I think a lot of you are probably already doing this and just didn't realize that this was falling under this new concept. But so, for example, a lot of states have started to, at least 10 at this point, have started to enact legislation that limits an employer's ability to dig into credit history. You know, with recent financial times, a lot of folks are finding themselves with less than stellar credit reports, which is also starting to have an impact on people's ability to find employment. So states have said, you know, unless that person's going to be in some sort of position with fiduciary responsibility or access to cash or access to client financial information, there's no need and you're not allowed to run a credit report. So that's a concept of a narrowly tailored policy. Rather than just saying, okay, I'm treating everybody the same, I'm going to look at everybody's credit regardless of what position they're applying for, you're starting to see why a narrowly tailored policy is indeed the way to go. So limiting the inquiries to the essential functions of the position. Likewise, we do a lot of motor vehicle record reports for our clients. If that employee is not going to be driving either their own vehicle for company purposes or a company vehicle, really no need to inquire into the motor vehicle record history. So you can see the motor vehicles, the credit, applying a narrowly tailored policy based on the requirements of the job it plays into this concept of the EEOC's best practices. So one thing that you can do, and it will also help enforce and another practice which most of you should be doing, if not all, is having written job descriptions, well-defined job descriptions for each position. And what we're recommending to our clients is to take those job descriptions and then to add another section that would say, what types of criminal offenses would disqualify a person from holding that particular position? So that involves identifying the essential job requirements and what's actually involved in doing the job. And then also it plays into another thing which we'll see on the next slide is about documentation. So the EEOC is looking for some sort of proof that you've actually given this whole concept some thought. And one really good way of doing that would be documenting those essential job functions and the disqualifying offenses in the job description itself. And then likewise, you can look at not only the offenses, but going back to one of the green factors, you can say, okay, so yes, this type of offense would be a disqualifying offense, but Does that mean forever, or does that mean less than 7 years old? That would be another thing that you could include. So I realize a lot of folks start to bristle at the thought of the EEOC telling me who I can and can't hire. You know, arguably that's always been in effect at least as long as that agency has existed. But you know, one of the things that we were worried about, and kind of half-jokingly said that, you know, what is this doing? Is this creating a protected class for convicted criminals? And I don't think we're seeing it go that far. Again, I think it's trying to find the balance of saying, is this person permanently disqualified from all employment based on this past behavior? And that, you know, that's going to have to play into each individual employer's risk tolerance. And you know, whether or not they feel like they are a high level target for the EEOC, somewhere kind of balancing all those factors together. But just going on with the EEOC best practices, as I mentioned before, the documentation is going to be key. And then, you know, because the EEOC loves these white papers and there's all this social research that's going into their own policies and procedures, if you have consulted any type of study or anything that has helped you come to a decision about your processes, document those. Just make sure that there's some sort of almost like a legislative history of your own internal policies and procedures. Believe me, the more you can throw at the EEOC investigators when they come knocking, the better off you're going to be. A lot of people feel that's maybe somewhat counterintuitive. It's, you know, being hung with your own rope. But I do think, you know, there is a balance there that you can find the right perspective. And I think having that information is better than not having it when the investigation comes around. And then lastly, of course, all of this policy and procedure is of really little value unless you're training your managers and those involved in the hiring process how to go about applying it. So just make sure that the folks that are doing the interviewing, the folks that are either recruiting or involved in the hiring process, understand that you can't just look at that resume or you can't just look at that background check, see the red flag, and just toss it in the trash. It's going to have to go through a little bit additional consideration just beyond that. So as I said, you know, there has been some litigation that's kind of starting to wind its way through the court system on this issue of individualized assessment and you know, looking deeper and how criminal records are being used to screen out employees. There's a couple of cases that are active right now. Unfortunately, we don't have resolution to those yet to see how exactly they're going to pan out. But I think when you look at the facts involved and the scenarios, you'll see exactly what the EEOC is looking for. Because whether you went into this thinking that, you know, the EEOC is not going to tell me who I can hire, I'm not going to hire any darn criminals, I think you might see it a little bit differently when you see these fact patterns. So the first case that we're going to kind of take a look at is this case against BMW. It's also involving a couple of contractors that BMW used, but the general idea here is there was a situation where BMW employed a number of workers in one of their factories. They were all employees of this subcontractor. Well, BMW was changing subcontractors, and as often happens, the people that they had actually working in the building, they kind of wanted to keep some of them because they knew the job, they knew what they wanted to do. So basically what they had to do was they left the employee of this one contractor and went to get hired at this other contractor, which now had the contract for that factory. And in the course of doing so, these employees, some of whom had been employed for numerous years, in some cases 14, 15 years, were basically reapplying for the job that they currently had. And the new contractor had a slightly different policy enforced by and suggested by BMW about their criminal records. And so there were individuals that when they reapplied and the background check was run, they had some disqualifying offenses. In one case, an employee who had been there for 14 years had a very minor drug conviction in the past, was basically told that he was no longer eligible to work there. So for the last 14 years, this employee, fine employment record, no problems whatsoever, was all of a sudden no longer qualified. And so the BMW case, just that's the EEOC jumped on that and said, see, that's exactly what we're talking about. That doesn't make sense. How can a fine upstanding employee of the last 14 years now all of a sudden be disqualified? Why? And so that's where this concept of individualized assessment kicks in. Had they looked at that individual's employment record and seen what a fine upstanding person they were, despite a 14-year-old drug conviction, they would have said, yes, by all means, this person can work here. It makes sense. So that's the BMW case. There were a few other examples that I think also stood out that the court will certainly be taking a look at. But I don't know if that has kind of swayed your opinion. Maybe just apply that to your own set of employees. Imagine walking through the office and all of a sudden one of the employees that's been there for 14 years, you realize that they had something in their past. What does that do for you? Now, obviously, depending on what that past is, that certainly factors into it. But if that's your answer, then you're making the point. Is you have to dig deeper. Bright line test, a black and white printout of a person's background check isn't the whole story. So another case that was filed pretty much at the same time was against Dollar General. Situation was sort of the same, but a little bit different scenario. Here we don't have subcontractors and people reapplying for their jobs. Here we have a couple of examples. One applicant was denied a cashier position because she had a 6-year-old drug conviction. I believe even there was a self-disclosure on the part of the applicant in that case, but nevertheless, the drug conviction popped up on the background check, and Dollar General said, sorry, anybody with a drug conviction just not qualified to work here. So the challenge in this case was that the individual presented with a history of successful employment with another discount retailer for several years. So she had been employed in a very similar position. It may have been a slightly different industry. It may not have been like a dollar store, but I do believe it was a retail position. So holding down a similar position for 4 years with no trouble. So why then is this person disqualified? So the EEOC said, see, there's another example of what we're talking about. Also with Dollar General, there was another applicant who had a background check that came back, and she had advised the store manager that the background check was incorrect and that the information didn't actually belong to her. Probably had a common name or one of those typical things that we see where information gets crisscrossed in those files. But in this case, they said, sorry, you've got a conviction, it's not going to work, move on. So that actually brings up a couple of other problems. One, the process of allowing an applicant to correct their information and have an opportunity to respond before an adverse action occurs. That's another big no-no. But in this case, the EEOC hadn't quite focused their attention on that. That would be more of an FTC situation. But the EEOC basically said, see, here's another example. This person didn't have any opportunities here to correct information about a background check, and I believe they also had another similar history where they had not had any problems. So these two cases, as they get through the court systems, I think we'll see some more clarity on this. My guess is, just based on the recent trials and tribulations that the EEOC has gone through with respect to their court cases, a few black eyes in the realm of background checks. My guess is they're going to have their ducks in a row on these two cases, and it's not going to fare too well for either BMW or Dollar General. So we'll continue to update our clients on this, and once we get some kind of ruling, we'll probably do another webinar on the subject. But for now, just take these two examples that we provided from Dollar General and BMW and see what you can learn from those. I think it's fairly clear that in situations where people have held down jobs with a decent work history past some sort of event or incarceration or conviction, you may need to take a second look at that. And again, I won't go too far onto the soapbox about the EEOC telling you how to run your business, but in this case, I think you really do need to look at it and determine whether or not that's a risk that you're willing to take. So for our takeaway points on this, really I think we didn't really focus too much about the job application, but that's another thing that we're seeing out there is in conjunction with the EEOC rulings, we're starting to see a lot of states pass what they call a ban the box statute, which pretty much takes the checkbox off of the employment application that indicates, have you ever been convicted of a crime? So a lot of states, in conjunction with the EEOC, are trying to push the background check inquiry further into the hiring process and making it much less of a pre-screening tool as more of being part of a conditional job offer. So you might consider that, you know, if your application has that checkbox on there for ban the box, consult with your attorney and find out whether or not your state has passed a ban the box legislation. You may need to change your application, and you may want to go ahead and do that in advance of any legislation, just because I think it might give you a little bit better position with the EEOC should they do any type of inquiry into your hiring practices. And then from the get-go, I think we've talked about eliminating the bright line rules. I think that's just not going to fly anymore with the EEOC's new position on this. So saying nobody with any kind of conviction of any type is not allowed, I think that's something that you're just going to have to eliminate from your practice. At least have it tied to the particular essential elements of the job. And so, again, I think if you break down each job function into its component parts and determine what criminal convictions would disqualify that person, obviously anybody convicted of embezzlement probably wouldn't be a good candidate for your controller or CFO position. So, again, I think common sense really still will prevail in this, but I think if you try to say, well, anybody with a drug conviction surely isn't qualified because they could go off at any time and who knows what. I think you can't really stretch this into another way to do a complete bar to employment. So just make sure that you're adjusting your decision criteria. And then finally, as we said, I think the more you can do to push the background screening and the inquiries into their past into a conditional job offer, I think the better off that you're going to be. So I appreciate your time today. I know we kind of did a deep dive on this subject. We've talked about this before in kind of in a passing fashion, but it really is one of those areas where we're starting to see some increased litigation. I think since it really is primarily driven by the EEOC, I think unless you're a large employer or you have a huge number of applications going through your offices, you may not show up as a target yet, but certainly not a reason to shirk responsibility on this and at least take a look at it. Because the EEOC has revised their enforcement practices. They've got their enforcement strategy mapped out for the next 3 years. And that's available on their website, by the way. It does provide a little bit of an interesting read. But this is where they're headed. So just evaluate your practices and procedures, and hopefully you can stay one step ahead.
Matt, we have some questions that have come in, and we have a little bit of time. So there's one thing. There's a couple things that we want to address. The only place I saw the word character had to do with character references. And it seems to me that employers are really wanting to make sure that before they hire someone, that they're trustworthy. In other words, they may have made mistakes in their past, and it was a mistake of judgment. And clearly, if their record is clean post incarceration for a period of time, or they show good work habits and good work ethics on the job, then that speaks potentially to their character. But in the references, and is there an opportunity really for a hiring manager and a hiring company to really pursue the question of trust and trustworthiness on the part of applicants?
Yeah, I think so. And honestly, I think references are really an underutilized tool. I think it's maybe out of this misperception that the only thing that you're going to get from any former employer or anybody really is a name, rank, and serial number out of fear for libel or slander or whatever the real fear is there. Never have really understood that myself because, and I guess it's maybe because of my formal training, but I mean, libel and slander are pretty hard to prove, especially when truth is a defense. So if all you're stating are factual matters, then really there's isn't going to be much of a problem with libel and slander. But I think that references are an underutilized tool. I think there's more information out there available than you might expect. And to not even try because you think you're not going to get anything useful is probably somewhat of a defeatist attitude. Because we do that all the time for our clients. We verify employment, which is different than doing a reference. So I mean, certainly we can verify and get the name, rank, and serial number, but we do employment references all the time, and with the right training and the right series of questions, we can get all kinds of information about character and trustworthiness and performance that you wouldn't have thought possible. So,
And can a hiring manager ask questions along those lines as well when they're interviewing a candidate?
Oh, absolutely. Yeah. I mean, I think I read a lot of articles and journals on the subject of interviews and the like. And I think for the most part, most of us, and probably including myself and many times, are just doing it wrong. I think we're focusing on the wrong things. I think too often we forget that the right culture, the right fit is sometimes more important than whether or not they have the right training. You can train on just about anything except for character and ethics. And so I think opening that line of question and trying to elicit some responses on those subjects is probably paramount in an interview process.
Okay. Well, good. Thank you. I think that's answers that question. Let's say that somebody has a DWI. What and that possibly that comes up, and I guess you check their driving records as well in background screening. So, what's the impact of DWI on the screening process and on the hiring process?
Sure, and we see that fairly frequently. It can come up both on the motor vehicle record report, and if there's a criminal case involved, sure, it'll show up there as well. So I think what you have to do is ask yourself and ask the applicant, is this ongoing behavior? Is this something that you have under control? Is this something that's in your past and is going to stay there? I think you also need to evaluate whether or not that person has any the position for which they're applying, whether or not there's any driving responsibilities. I mean, I think most people have to drive to get to work. I guess a few of us that are lucky enough that live within range can bicycle or walk or whatever. But I think on average, at least in my part of the country, which is right here in the right smack dab in the middle, we're driving everywhere we go. and so that's an unavoidable part of getting to work. And so you might think, well, if they can't keep it together to get here, are they going to be a reliable employee? And that's a fair question. So I think you do need to sit down and address that with the applicant and just find out what the circumstances were, and determine whether or not that's going to impact your decision. I think to just automatically assume that, well, once a drunk, always a drunk, and if they've had one instance, there's usually followed by more, and oh my gosh, I just can't take that risk because what if they crash their car on their way to work? Well, I think that's certainly one way of looking at it, but I think that's the type of exclusion that I think is going to get yourself into trouble. Because I think if you really did sit down with a person, they said, yeah, it's always on the weekends, and maybe they won't say that, but it was a one-time thing. It was on the weekend. It never happens. I'm not a morning drunk. I think you just have to ask the questions and find out what the situation is.
Well, while we're on the topic of drugs, what about states where medical drug uses are now permitted?
Oh yeah, that's probably another webinar in itself. It's a huge topic. A lot of folks think that because the state and that they live in has decriminalized the possession and use of illegal drugs, that it's okay, that they have a license to do that whenever and wherever they want. Well, that's not true. Even in the states where they have decriminalized the possession and use of illegal drugs, they still remain illegal at the federal level. And an employer, as part of a safety program, can still prohibit the use of drugs. They can still drug test. They can still terminate your employment based on testing positive. Whether you were using that on your own time and whether the state minds or not, all that is still mostly irrelevant. So yeah, I think there's in Colorado and Washington State, I think there's been some employees that woke up and found themselves no longer employees, and they were a little bit surprised by that. So employers still have the ability to control and provide a safe working environment in spite of any type of decriminalization of the illegal drugs.
Maybe we'll invite you back then to talk about that whole issue of drugs, the effects on persons, and what companies can do about that, especially given, high health costs that are related to that and so forth. But time doesn't allow us to continue that, so I want to ask one more question before we wrap up for today.
Sure.
And I think this really kind of gets at the heart of your webinar, and that is, let's say that you have two applicants, and truly the only difference between the two applicants is that one has a criminal record that is now, 7 years hence, or maybe it isn't, but it has a criminal record. However, they do show that they have the skills, the competencies for the job. What opportunities does the hiring manager have to now say, well, because, though they both have the same level of skills and they both qualify on that for the jobs, we're going with the applicant without the criminal history or criminal activity in their past. Do you have any comments about a situation like that?
Sure, and basically it'll go back to the origins of the EEOC's involvement in this in the first place. So I think all other things being equal, same qualifications, same education background, same work history, and then one of those applicants has a criminal past, I think you're still okay making a decision to take the qualified non-criminal past applicant over that other person. The challenge where you're going to run into with the EEOC looking at you is if over time a pattern develops that the applicants with the criminal past all happen to be members of another protected class, and you're always picking that other applicant over that the criminal past applicant who also is in another protected class, then you start seeing a pattern emerge where the EEOC would say, well, you're not picking the qualified individual, you're picking the non minority applicant. And that's the challenge with the background checks. I don't think that the EEOC really has a problem with background checks per se. Maybe I'm wrong. Maybe I'm being naive. I think what they're looking at, and just from the language that they've used from the beginning, is that background checks or people with criminal records, not denying employment for criminal history, is really just a pretext for, say, racial discrimination, because it's having a disparate impact on another protected class. So that's the only way I think that you're really going to get into trouble, is if all of your applicants that you're overlooking with a criminal past are minority applicants, and you're always picking the non-minority applicant, then I think you might have an issue.
Okay.
But
Wow.
that's, unfortunately, I get to throw out my typical law school answer is, well, it's a case-by-case basis, and unfortunately, it really does kind of boil down to whatever fact pattern that you're looking at. But I really do think that if you have if you take out any pretext for racial discrimination out of the equation, and you really are faced with a qualified applicant with a criminal history and a qualified applicant without, I don't see how you could be faulted for taking the one without.
Okay. Well, thanks for answering that. And I think that was a good answer to show really boils down to the pattern, boils down to the company's hiring policies and their practices. So I think that was very informative. You want to tell us about what you'll be talking about next month?
Oh, I can certainly give that a shot. Yeah, I think what we're looking at is some of our FAQs, our frequently asked questions. So many times people come into the world of background checks with a very limited understanding of what's involved, just like I did 3.5 years ago. There's just so many different things that pop up. You had a number of questions that came in, like the drug screening question. How does that work with the states that have decriminalized some things? And then just really, there's so many different types of things that can go into a background check. So really, the frequently asked questions, we've got a really good list of those, and so we'll just answer some of those questions that come up, and hopefully that, typically when we do a webinar with a topic like that, and we open the floor up to questions, we get a lot of interaction. So that'll be part of it as well.
Okay, very good. And I'd like to go ahead and switch screens so that I can show what we have coming up next as well. See if we can do this, make this work. Folks, we want to go ahead and invite you back next week, and I'll show you in a moment. This should work well. There we go. We have next week, Are You Leaving Money on the Table, with Kenna Lewis. And Kenna is our socialista. She is social-centric media, and she'll be talking with us how to really monetize your social media. So this will be a great topic, and she's been very popular in her series talking with us about social media. And then back after that is Sources of Return on Investment, Return on Resources, with Dr. Jeff Stewart, as he talks with us about what are your true sources of return on investment and return on resources. In other words, how can you source and improve and increase your return on investment and your ROI and ROR. Then we have Rally the Team for Success. We have our popular Emily Shoup from Shoup Training and Consulting, and she'll be talking about ways to really get your team energized. And so we welcome you back on Tuesdays at noon Central. And also we invite you to come out and join our business performanceusa.org and become a member, and you'll be able to watch Matt on all of these various webinars, as well as Nancy Roberts, owner and founder of Track One. We will invite you back for webinars. This is a way that you can hear about what's coming up and hear about what issues we'll be discussing on these weekly webinars. So folks, come back. We'll see you next week. We appreciate your time and your interest in today's topic, and we look forward to hosting you back in the future. Thanks, everyone.